Welcome to Versus Trump, the podcast where we talk about how the Trump administration is breaking the law and what people are doing about it. I'm one of your hosts, Jason Harrow, and I'm here today with Isha Anand. Hey, Isha.
Hi, Jason.
And Charlie Gerstein is here too.
Hello. I change my response to you every time just so that people don't think we pre-record all of this and just play the same thing every time.
We do not.
I try to come up with a new thing to say each time, and this is, a meta new thing to say.
Wait, Charlie, you worry that our listeners think we bothered to record a podcast about a new lawsuit
yeah, we do one good intro. But we can't master
all right,
the
listeners,
intro.
well, in case there's anyone out there worried about this, I'm glad we were able to debunk it.
Yeah, but we've got a really juicy lawsuit. We feel like this week we're really returning to our roots of trying to help you through really wonky, nerdy, fascinating to us and hopefully to you legal stuff. So this week we're going to talk about a case with among the most boring names that a case can have. It's called In Re, which is RE: Border Infrastructure Environmental Litigation. So you don't even really get to know that it's versus Trump. But trust me, listeners, it's versus Trump. The reason it has this long title that is not a V is because it's consolidating a bunch of cases, all of which are versus Trump, or rather versus the Secretary of Homeland Security. So these cases that we're going to talk about are brought by environmental groups, public interest groups, and the state of California. And it is a challenge to the Secretary of Homeland Security's authority to fast track the border wall in San Diego and in Southern California. So super political topic. There was just a fascinating long opinion on this case on February 27th, and we're going to get into that. So the preface, it will be quick. TakeCareblog.com/podcast is where you can find us online. You can also find us in iTunes or your favorite players by searching for Versus Trump. You can rate us there. And what else? Oh yeah, emails, versustrumppodcast@gmail.com. The inbox is slowly, gradually increasing. We hope that we're finding some more listeners, or existing listeners are more willing to email us your thoughts and questions. And we love that. We read everything. So appreciate it. On Twitter, we tweet out usually when there's a new episode at Versus Trump.
And we should note that we got, speaking of email inboxes, we got our first fan art this week. So many thanks to Ben Meiselman for sending in some cool t-shirt designs for our next printing.
Yeah, Ben was worried about walking around with a picture of Donald Trump on his t-shirt, which is a good worry that we hadn't really thought of when we came up with the logo.
True that.
So thank you, Ben.
True that. So next round, so guys who didn't get t-shirts this time, next round we'll try to come up with a design that doesn't involve the Trump face.
Yes,
on it.
Though, Isha, I should remind listeners before we get into it, there are the old versions still available for purchase. You can go to takecareblog.com/podcast, and in the first couple of paragraphs of the description, you can find the link to buy the old version. But yes, Ben has given us reason to maybe design a new version, maybe for the summer or the 1-year anniversary of the show or next holiday, something like that. Okay, so shall we get into In Re: Border Infrastructure Environmental Litigation, which I promise not to say that name again. But here's what's going on in the case, and it's also relevant that listeners may recognize the name of the district judge in San Diego handling this case. His name is Judge Curiel, and he was the subject of some serious back and forth, or really forth from the president. He didn't say anything back about his so-called Mexican heritage, and that will become relevant. He makes a really snide, subtle dig at that remark at a point in the opinion. So Judge Curiel has the case, and the case is brought by California and a bunch of interest groups, and they are challenging two actions that the Secretary of Homeland Security took in the summer and fall of 2017. And the actions are pretty extraordinary, and actually listeners not familiar with this law may be somewhat shocked that this can even happen. And these are waiver determinations. And what we mean, and Charlie and Isha, please interrupt me if I'm getting too boring or wonky or not making any sense. But these waiver determinations are a unique feature of the border wall, and they come because Congress has repeatedly amended these statutes that give the Secretary of Homeland Security authority to build certain sections of border wall and then do something extraordinary. And the extraordinary thing that the Secretary of Homeland Security is allowed to do is issue a waiver, and that waiver will give the federal government the authority to ignore all laws that would otherwise apply at the border, state and federal, purely in service of building these border walls. So to get a little technical, the secretary is allowed in his or her sole discretion to determine that it's necessary to ensure expeditious construction of these barriers and roads. And if the Secretary makes that finding, it is allowed to, quote, waive all legal requirements. So that's a stunning grant of authority. And it's been used in the past and for limited purposes. But Donald Trump is the president who came to office, as you know, Charlie Anisha, with the strongest pro-border wall platform. And so he directed his Homeland Security to take a look at this. And they did. They used it twice at issue in this litigation, once in August of 2017 and once in September of 2017. And those waivers enabled the federal government to start building a couple of different sections, some so-called prototype section of wall, as well as to replace 15 miles of border fence near San Diego. By the way, caveat, most people, Trump has promised to build this beautiful border wall. We actually already have over 700 miles of border fencing. So some of this is actually replacing existing fencing. But nonetheless, that's what the Secretary of Homeland Security did, and the state of California, where the wall will be built, these sections of wall will be built, and environmental groups who have an interest in not having things like the Endangered Species Act waived, and the National Environmental Policy Act waives, the Coastal Zone Management Act. So all of these environmental regulations and laws that typically apply to any federal government project don't apply. It's almost like this law allows the federal government to operate in almost a United Arab Emirates or China style environment of no litigation, no environmental impact statements, no endangered species protection, just build the wall. It's pretty extraordinary. Okay, so Charlie Anisha, as you know, these public interest organizations in the state bring these lawsuits. We want to highlight three in particular. And those three are the argument that the Secretary of Homeland Security used this waiver authority in a way beyond this broad grant in the statute itself. And then there's two constitutional claims, and we'll get into them. The constitutional claims that we want to talk about, there's a bunch here. We want to talk about something called the non-delegation doctrine, which is supposed to prohibit Congress from just giving all the legislative power to the executive branch. And we want to talk about a really intriguing argument that California made based on a case called Shelby County. And it's a 10th Amendment state sovereignty type argument where basically California is saying, hey, you're discriminating against our state laws and laws that apply in California because you're not waiving laws for the Canadian border, say, or for any other state. You're applying these directly to us. So that's the milieu. Charlie Anisha, did I forget anything, or should I move on to this more astounding introduction that Judge Curiel writes?
Astounding seems a bit much, but yeah.
So can I just take issue with? So I don't know a ton about environmental law. So listeners who do, please feel free to push back. But my understanding is that this waiver allowing you to ignore environmental laws is not so extraordinary. So that is, Jason listed a couple of environmental laws, including the National Environmental Policy Act, which I learned this week is known as the Magna Carta of environmental laws, because it's sort of the founding document. But essentially, NEPA imposes sort of an information gathering requirement, like you've got to come up with a statement about how this is going to impact the environment, and you have to consider that. But it doesn't actually include any kind of mechanism to force you to do anything. That is, under NEPA, hypothetically, you could say, like, we gathered all the information about the environment, and you know what? It doesn't matter to us, even though it's got this really dramatic environmental impact, we're going forward, and that would be allowable. And because it's only a requirement of information gathering and kind of consideration, not a requirement that you actually do anything to protect the environment, just that you be informed about the environment when you make your decision, I think it's somewhat common to allow waiver for projects that you want to get done quickly for whatever reason. So that's not just the border wall, but after Hurricane Katrina, there are a bunch of provisions that allowed for this. Interest groups often ask for it. So there's a bill on behalf of like the Northwest Timber Alliance or something like this that allows like logging in certain regions of the Pacific Northwest to be exempt from these various environmental laws. So the idea is that because NEPA sort of embodies this really good instinct, which is like, we should care about the environment. Everyone should think about the environment before they take any action. Everything we do affects the environment. Therefore, we should all be thinking about it. But because it doesn't like have teeth or constrain the ultimate outcome, it doesn't feel, I think the Congress generally doesn't think of it as super onerous to just waive it. So I just want to make clear to listeners that this is a big deal that DHS is allowed to just waive compliance with all these environmental rules, but it's something that Congress actually does a fair amount, that they find NEPA especially, but these environmental laws kind of burdensome, and so they'll waive it for after disaster relief or the emergency salvage timber sale program in the Pacific Northwest for logging, or whatever else they think needs to get done quickly.
So
Yeah.
I think Jason's point was, and if I'm getting this wrong, someone correct me, and particularly Jason, because it's your point. I don't know of any other circumstance where the government has allowed a cabinet secretary to issue a blanket waiver of all the law, right? It's not specifically environmental law, as far as I can tell. It's any legal obstacle to building this section of wall. Is that right, Jason?
That's right. It's actually more than 30
And
laws.
I can think of no other time that's happened.
Correct, including criminal laws. And let's just elaborate, because it is a good point, Isha, and this opinion doesn't have a lot about what the actual practical effect will be. So, but let's bracket that and just talk about the legal guts that I hope our listeners like to dig into, which is that, yes in my view...
Wait, before the legal guts, we have the prefatory, explicit disclaimer of policy judgment. So let me talk for a second about that. Basically, there's a habit of particularly district courts, but courts of appeals too, to begin opinions in cases that touch on politically sensitive subjects but are not ultimately disposed by them with a paragraph about how this court doesn't consider politics or whatever, which is an almost necessarily self-defeating statement. By saying I'm not considering politics, it's like talking about I'm not thinking about the giant pink elephant. Of course, I hate it when people do this, but there it is. Except what's odd about this one is Judge Curiel begins with the following statement in his opinion. As fellow Indiana native, Chief Justice Roberts observed in addressing a case surrounded by political disagreement, quote, "Courts are vested with the authority to interpret the law. We possess neither the expertise nor the prerogative to make policy judgments. Those decisions are entrusted to our nation's elected leaders who can be thrown out of office if the people disagree with them," citing, of all things, the Obamacare cases. And this just struck me as really fascinating. So Curiel is from Indiana. Roberts is from Indiana. Donald Trump sort of disparaged Curiel for being Mexican, which he is not. He's from Indiana. And that seems to be a conscious choice here. Jason, in your intro, you thought that it could also just be someone who is so bored by the other 99 pages of this opinion that he has to grasp onto one personal fact, which is Chief Justice Roberts is from Indiana. But yeah, it's interesting to me. I'm mystified by it.
Oh, it's obviously deliberate, right? And this was this was kind of the memed response that went viral. It was like Trump referred to him as a judge, not just as Mexican, but as the judge from Mexico. And then, every newspaper in the country was saying actually he's from Indiana. So it's obviously an Easter egg. It's got, everyone on Twitter is quoting that passage, obviously what he wanted. I thought it was a totally appropriate and restrained dig.
Yeah, it was restrained, but I called it astounding. Perhaps that's just because I really like this case and I'm enthusiastic about talking about it.
You're really enthusiastic about this case, Jason.
I am
you're really pumped up.
Because there's so much here which I want to get back into. But yeah, so just to kind of close the loop on the intro, Isha and Charlie, what you were talking about was President Trump, then candidate Trump, had really bad things to say about Judge Curiel when he was presiding over litigation involving Trump University, and he ruled against the president in a kind of procedural and preliminary information release issue. And the president went after him on Twitter and in interviews saying that, of course, he was biased because he's Mexican and he doesn't like my position on the wall. And lo and behold, Judge Curiel gets this case involving exactly the president's position on the wall, sides, I don't know that we've said this yet, but sides completely with the Trump administration here. Gives the Trump administration a 100% total victory. Can't resist pointing out that he is from Indiana. To correct the record, he's not Mexican. And that I took this quote from the Obamacare case. Yes, I understand, Charlie, you're saying judges put this in, we're not considering politics. But I took this to say everyone knows Chief Justice Roberts probably didn't like Obamacare, but he gritted his teeth and did it. I took this to Judge Curiel, maybe even signaling, look, this is a little crazy what we're doing. And he's got that line about being thrown out of office, which perhaps the voters will do in 2020. But for now, Judge Curiel is going to let the Trump administration do it. So let's talk about why. So, and this goes back to the thing that you talked about earlier, Isha, is the extraordinary nature of it. But the first thing that all the plaintiffs contend, and that Judge Curiel devotes about 60 pages of this long opinion to, is whether the Secretary of Homeland Security actually has the authority to waive these requirements in this case at all. And the reason that's in dispute is, and we'll try and simplify it, but it's actually because of the phrase "this section." So as we said, the Secretary of Homeland Security in this law has authority to waive all legal requirements if the Secretary makes certain findings in his or her sole discretion. And the finding that is necessary is one to ensure expeditious construction of the barriers and roads, quote, under this section. And that section, and this is hard to talk about on a podcast or radio, but is in subsection C, there's the statute with 3 subsections, A, B, and C. And the phrase this section is used in subsection C, but subsection C doesn't have anything in particular about barriers and roads. The barriers and roads are discussed in subsection B. And then subsection A is just an in general kind of purpose statement that Congress gave. So the question is, does the Secretary of Homeland Security have authority to waive these legal requirements for any construction of border wall, arguably in this zone, or only in the specific sections that were contemplated back in the mid-2000s when Congress actually passed that law? And Judge Curiel goes through every nuance of this type of argument and looks at legislative history and looks at every phrase in the statute and basically decides, interestingly, that it's ambiguous. And because Congress really wanted to curb judicial review of this particular statute, which is also extraordinary, Isha, it's another thing I wanted to mention about how extraordinary it is this law has very limited judicial review. He basically says, I'm going to defer to the executive. So, Charlie and Isha, I know that's a little high level. I don't want to get, too bogged down, but we do want to get enough into the weeds for listeners to understand it. What do you think of this argument? And what do you think of the deference that Judge Curiel gave to the administration here?
So, Jason, I'm not sure there's another way he could have ruled. And to understand why that is, I think it's important to kind of think through the way the statute is structured. So as you said, one kind of remarkable feature of this statute, and this was passed back in 2006, it's the Secure Fence Act of 2006. So one remarkable feature is it gives the Secretary of Homeland Security authority to waive all laws in order to build a border wall. The other thing is that it says as to federal court review, ordinarily when an agency takes an action, there's like the agency action, and then you go to a court of appeals if you think that the agency was wrong, and that wrong can be violated the Constitution, violated some kind of procedural rule, violated a statute, could be any sort of wrong. But here it basically says, A, you have to go to district court, not a court of appeals. And from the district court, you can't go to a court of appeals. You have to go directly to the Supreme Court. And B, you can only review claims that allege a violation of the Constitution. So that means you can't, on the show in this past, we've talked about the Administrative Procedures Act, which lays out kind of a detailed framework of kind of things that administrative agencies have to do and take into account in order to take any action. But that's not the Constitution. That's a statute. So you can't bring any challenge that just relies on a law that Congress has passed. You can only challenge something that's a violation of the Constitution. And so here, what the plaintiffs are kind of stuck doing is really what they'd ideally like to do is say, this waiver is nonsensical. It doesn't make sense given, agencies are supposed to act rationally. But they can't do that because those aren't constitutional claims. And so what they're stuck saying instead is they're stuck basically saying this is what's called ultra vires, which is that it's beyond the discretion of the secretary to do. There's some question about whether that argument is even reviewable. So to get kind of metaphysical for a minute, the statute says the secretary's decision to waive shall not be reviewable except for constitutional violations. And plaintiffs are saying, but you have to at least review whether the secretary was even allowed to make the waiver. And I think that probably the case law on this point, as fascinating as it is, a little too wonky to get into in kind of an auditory medium. But let's just say it's at least a close question whether this argument even works. And basically what Judge Curiel says is, all right, the best you can take from the case law on this is if someone's making an ultra vires argument, it's got to be basically like you are there's a clear and mandatory part of the statute that you're violating. So the standard is super high. It's not just like reasonable argument A, reasonable argument B, which one wins. Plaintiffs basically have to show it is a slam dunk that you did not do what the statute was saying, therefore you can't fit within this little zone of protection where you're shielded from judicial review.
Exactly. So Isha, and you're on a great train, but I just want to interrupt with a possible example. This wasn't in the opinion, but one thing I was thinking about when reading is, if the secretary had waived environmental laws and other laws at the U.S.-Canadian border, for instance, right, which is not discussed at all in this provision, that's arguably far outside the secretary's authority. Or if he or she did something completely different, waived environmental regulations for a project unrelated to border wall building, arguably that's reviewable. Right. But as you said, Isha,
right. I actually think the Canadian border one probably not reviewable, right? So
but non-border wall, you think non-border wall?
Non-border wall, I think. Okay. Right. It's got to be a physical barrier or road. Okay. So, and as Jason was saying, basically the way plaintiffs try to get at this, and I want to recite this just because it gives you a sense of like what lawyers do all day, because this is such a classic statutory interpretation case, that the way that this is structured. So they say, as Jason explained, there's a provision A, which says such actions as may be necessary to install additional physical barriers and roads in the vicinity of the United States border to deter illegal crossings in areas of high illegal entry. So as Jason says, they challenge every part of that. They say these aren't additional physical barriers and roads. Part of this is about replacing a border wall in San Diego. This isn't to deter illegal crossings, because it's in fact not going to do that. And they say it's not in an area of high illegal entry into the United States. In fact, the way that most illegal entrants get into the U.S. is they overstay a visa. And so in addition to the kind of, as Jason explained, the question of whether this section refers to what I just recited, the kind of general authority to install physical barriers, or this section means specifically a narrower provision about the southwest border. They also basically say, look, even taking this really broad grant of authority, it's a broad grant of authority to do something specific, which is additional physical barriers to deter illegal crossings in areas of high illegal entry. And they say this is none of the above. Not additional, not deterring, not high illegal entry. And Curiel, I think, quite rightly sort of says, look, I said that I'm only going to entertain this ultra vires authority question if it's, as Jason said, you're building a wall in Kansas, right? Reasonable minds may be able to disagree on whether or not this is going to deter illegal crossings, but that is not the kind of mandatory language that leads me to ignore the provision foreclosing me from reviewing this and say that this is so outside the scope of the statute that I actually can review it. And I think that's right. I mean, I commend plaintiffs on this theory, on taking advantage of every sort of clause of language in this whole statute that could prove limiting, but I'm not sure. I mean, the Secure Fences Act was in fact passed to build a border wall. That was the point of the statute. And so, yes, this is a decade later. And yes, Donald Trump has been sort of nonsensical about his reasons for wanting to build a border wall. But I'm not sure that's enough to say that somehow the secretary is acting completely outside the scope of authority. It seems like this is precisely the authority he has under the statute, is to build something like this.
Yeah, this one seems easy. And it's worth noting, listeners, that we've spared you probably 3/4 of the claims in this complaint, and intend to spare you all of them. Like, the plaintiffs really threw spaghetti at the wall and waited to see what stuck, and nothing in fact did. And we'll get into some of the more interesting ones. I think this is that you guys are totally right. I mean, to belabor the sports metaphor still further, the cases refer to the ultra vires argument in this context as a Hail Mary pass, one that, as in football, is rarely successful. And for that reason. And so I suppose we should transition now, Jason, do you think, into their next argument, which is that
Charlie, let me interrupt
Congress couldn't give that.
Let me interrupt you first, because I want to point out one other interesting feature of the ultra vires argument that I think might shock non-lawyers, that I would be curious if any non-lawyers out there had ever heard of this before and could email us and say, and that is what, Isha, you mentioned in passing, but I want to focus on a little bit, which is the judicial review provision. So this provision was added in 2005 when President George W. Bush was president. And it, as you mentioned, Isha, says that any challenge to this particular action by the Secretary of Homeland Security goes into federal district court, has no appellate review, which is highly unusual, and then can only be reviewed by the U.S. Supreme Court if the U.S. Supreme Court chooses, non-mandatory review by the U.S. Supreme Court. Now, I just want to put in readers' minds, this is building a border wall on the southwest border, so concentrated in California and Arizona. The government.
Wait, Jason, we should note again that the general grant of authority is to build a physical barrier or road anywhere, right?
Correct. They'll focus on the southwest border.
Request,
exactly.
Right. There's a specific request that says you've got to do with the southwest border, but let's just be clear, listeners, that this is not even a narrow grant that's like a wall here. This is any physical barrier or road that would deter illegal entry. Sorry, keep going.
Correct, though clearly most contested in the southwestern border, and indeed subsection B, as you mentioned, Isha, has a lot of law titled construction of fencing and road improvements along the border, along the southwest border in particular. So I think that the Republicans who wrote this bill and George W. Bush who signed it were probably aware that the Ninth Circuit would potentially review a lot of these claims, and in particular claims brought in California and Arizona, which are two large states within the Ninth Circuit with many hundreds of miles of border wall. And Congress specifically said, no, Ninth Circuit, you don't get to do that. And what I want to point out to listeners, especially non-lawyers, is that's legal. I know that seems crazy, but that is legal. The U.S. Constitution only creates one federal court. It's the Supreme Court. It gives Congress the power to create inferior federal courts. And the way this has been interpreted by the U.S. Supreme Court over centuries is that Congress is allowed to play around with these things. It's called jurisdiction stripping in the federal courts classes that we all took. And it's fully legal. The Congress is allowed to say, hey, that court over there, I think many non-lawyers know that the Ninth Circuit has a reputation for being quite liberal. Lots of judges appointed by Democratic presidents. And they don't get to hear this case. They don't get to hear any case involving these issues. It's stunning to me. It's constitutional, I guess. I hope Congress doesn't. I'm glad Congress doesn't use it frequently. They used it here, and it's probably pretty effective, don't you think? I mean, I don't know if you want to move on or if you have any thoughts, but that just jumped out at me.
Yeah, I think that's a great. So, and this sort of links to something that I just wanted to flag, which is that. Right, this is not like this statute we're describing that has this kind of broad waiver power that allows you to kind of jump around to get the most favorable courts. This isn't something that like Trump passed somehow, right? This is something that was passed in 2006 that most Democrats voted for, got more than 80 votes in the Senate. And, you know, I think that even at the time, there's a bunch of coverage saying that this is more a slogan than a solution. It's a feel-good plan with little effect in the real world. But this plan to build 700 miles of fencing that was going to cost $50 billion back in 2006, I mean, Joe Biden and Hillary Clinton and Barack Obama all voted for it. Like, this was an incredibly popular measure. And kind of, as I was sort of like doing the research on the Secure Fences Act of 2006, and learning that in part Democrats were so enthusiastic about it because they viewed it as far better than other alternatives, which would have ramped up enforcement in other ways and made, for example, undocumented status a felony offense, which is, you know, particularly draconian, or would have ramped up kind of roving patrols in the interior. Like, Democrats were all for this. Some of them were sort of like, this is a little bit wasteful, but in general, they were basically like, man, this seems like a pretty harmless way to get something on immigration that we want. And so I'm kind of curious, like, when the border wall became so loaded, because reading the coverage of this back in 2006, it sort of seems like people thought it was silly, but not, you know, we're not willing to sacrifice anything over it. And of course, fast forward to today in the immigration debate, to simplify vastly, you know, Democrats don't seem willing to trade the border wall for saving Dreamers or DACA status, which we've talked about on previous podcasts.
Well, they did put that on the table. The last offer from the Democrats in the DACA negotiation did involve money for building the wall, although everyone was kind of crossing their fingers behind their backs because you can appropriate the money now for the wall and then deappropriate it later, right, when they don't actually build the wall. And
forget actual, you know, what the vote count will ultimately be. It's tremendously unpopular, so I guess what I'm saying. And so I was sort of stunned to say, like, in 2006, this not only passed overwhelmingly, I mean, like with more than 80 votes in the Senate, it passed with these provisions to like really expedite things in an unusual way by waiving all laws, by kind of streamlining and stripping judicial review. So I just thought that was really interesting, that it was not only that there's not only such a consensus around it, there was such a consensus around it that it was like, let's not let the ordinary machinations of rule of law get in the way of building this thing.
Yeah, I mean, we can't forget that Barack Obama deported more people than any other president in American history, right? Like, and the reason it's acquired different symbolic importance now is because Donald Trump uses these sorts of things in openly racist ways, right? So the wall now has greater symbolic meaning than it used to. It's now meant as an actual barrier between us, the good people, and them, the bad people. So yeah, when Donald Trump does it, it has different meaning than when Barack Obama does the same thing. And I think we'd all be fools to think that that means it's unimportant. So yes, the border wall costs lots and lots of money, and it's really, really stupid. And it probably is going to be a little bit environmentally harmful. But really what we're fighting against when we fight against the border wall is its symbolic meaning. which is no less important than what it actually does in a very real sense.
Can I ask, like, if I were looking at this case, my Hail Mary pass, because, like, let's face it, a lot of the claims in this case are sort of Hail Mary claims. My Hail Mary pass would be an Equal Protection Clause claim for the reasons we've talked about in the past, right? So there's a pretty strong canon that says that any action you take with a racist motive is an invalid action. It's an unconstitutional action that violates the Equal Protection Clause. We talked about this extensively in the Muslim ban context, right? Whether, the Muslim ban that could have been passed for good reasons, but since it was passed for bad reasons, we think it's unconstitutional. And it seems to me that if you could make that argument in that context, I'm not sure why you wouldn't make that argument in this context. Like, why wouldn't you say someone could surely build a border wall for pure motive? Here we have so much evidence, campaign trail statements since he's in office, the text of the executive order itself, that actually these motives aren't pure. They are unconstitutional because they're motivated by animus toward a particular group of people, namely Mexicans and Mexican Americans. And I was kind of curious, because Charlie, you're right, that's the thing that's troublesome about the border wall. And I was kind of curious, like, where am I going wrong? Why is that not sort of a centerpiece of this complaint?
I don't think you're going wrong at all. And I think for the same reason we discuss in all of those cases, there is actually no principled limitation to where that logic will go. And it is the fear of that absence of principled limitation that would cause every single court, no matter how liberal, not to reach that ruling. But that's not because in principle it's flawed. That's because in principles it is not flawed.
But you don't think this is as... we said that, and then we said, but if there's ever a case, the Muslim ban is obviously the case because he's been so blatant about what he's trying to do. You don't think the border wall is like the second best case of that? I mean, he's been so nakedly antagonistic toward Mexican Americans.
Yeah, I don't know if it's the second, but it's definitely up there.
And I guess it just feels like if we were all on board with doing this for the travel ban suit, and in fact, some courts were on board with doing this for the travel ban suit, it seems like why wouldn't that be the case?
I think in part it's because, just the Gestalti impression is that, it is also true that prior non-Trump administrations have tried to do the same thing. And that's not true of the Muslim ban. Right. And so there's at least some case for building the wall.
Well,
it's stupid, right? And what Congress was actually doing is throwing money at a problem that they had no plausible capacity to solve and being able to tell their voters, rest easy, people. We've actually put up a giant concrete wall. That's going to stop the problem. When, of course, airplanes fly over the fucking wall and people with visas are in the United States. And that's actually how people get to this country. But, it is, as you said, a feel good for people who like to feel good in a really bad way measure that doesn't really do anything. But the fact that some non-racist administration has actually tried to do it is a powerful point against the argument that usually applies in the travel ban case.
Well, yeah. Except that, even the travel ban case, the big argument was, well, the Obama administration actually picked these countries, right? Like that's
but it picked them for like extra scrutiny of visas. It wasn't turning people around while they were in the air.
All right. I mean, I understand that. It just seems to me that at the point where we're arguing that an agency acted ultra vires, which we should make clear to listeners is a very high bar to clear, right? It's like you have to act in a totally unauthorized manner. I just don't see why this doesn't sort of fit in. I mean, and we'll talk about the Shelby County argument, which I think is great and a lot of fun, but I don't think any more plausible than what I'm saying.
Yeah, no, and just to be clear, like, I think that you're absolutely right about it. It's the same thing that applies to almost everything Trump does, that maybe even that doesn't, but certainly that does negatively affect a group that he regularly disparages.
Right.
Yeah,
I mean, in this case,
Charlie, yeah, I mean, this is so interesting, and I'm glad we're talking about it because it was, frankly, Isha, I didn't notice that it should have been in there, and could have been in there, but it is what's underlying all this, and clearly underlying the nature of this challenge as well. But Charlie, I think that the problem, the limitless problem, is not just the limitlessness of the doctrine, but it's the limitlessness in a metaphorical sense of the reaches of the executive branch. And I think that courts, especially in a case like this, will have a really hard time thinking, okay, so the president said some arguably racist things on the campaign trail in 2015 and 2016, and he and some of his spokespeople have continued to use that kind of inflammatory rhetoric through his presidency. But okay, the Secretary of Homeland Security issued this waiver, after examining this. And
John Kelly said plenty of racist things himself. He was at the time.
I'm not disputing that, right? But the general problem here is, okay, so there's all these different actors. Are they all infused with this racial animus? And if so, what's the evidence? And if there is available evidence,
it's the same as it is in all the
Charlie, let me finish the point. If there is evidence, then what about these specific programs? Do plaintiffs? This is in a way, I think, maybe it's the same limitless point, but I take it as a somewhat different limitless point. Do these plaintiffs get to knock out every single border wall project? You know, what if Secretary Kelly had really good evidence that these 15 miles of border wall in San Diego need to be rebuilt, and he did a comprehensive study, and it was as great of an administrative proceeding as any in the history of the United States? Is it still infused with animus because on some talk show he said something that you, Charlie Gerstein, think can be construed as anti-Mexican animus?
Yeah, Jason. I mean, I think that's just as true here as it is in everything else, and we've talked about this on lots of episodes of the show. I mean, the problem, it is new to American constitutional law to have a president who is as explicitly racist as Trump is. And I'll, as usual, quibble with your point that these are arguably racist statements. Even Paul Ryan agreed that these were racist statements, and he's, a Republican. But so to transition into something else, one of the arguments that the plaintiffs raise here is that Congress has given too much authority to the executive branch. And we just wanted to briefly explain what that doctrine is and whether it applies here, if it ever applies anywhere. Basically, you got your basic separation of powers in the Constitution that has the judicial, legislative, and executive powers, and none can take the powers that belong to another, even when they're given the power. So the legislature can't pass a bill that says the president may make any law he desires. That seems uncontroversial. There is some limit to the principle of what's called delegation, which is where one branch gives its powers to another branch. And here the plaintiffs wanted to claim that Congress has given the executive far too broad authority, and that it is the equivalent of allowing the executive to straight up make law. There's basically nothing to this argument because the Supreme Court since 1935 has not invalidated a single delegation, although they have narrowed one. And here, Congress appears to have provided far more guidance than they do in lots of other kinds of delegations. For example, they will periodically pass a statute that says the secretary is empowered to make rules in the public interest. That, I think, was the high watermark of delegation doctrine. That was Whitman versus American Trucking, I think, was just you can make rules about trucking in the public interest or something. And if that will fly, then this will fly. So I think that one had no merit to it, and Judge Curiel seems to have agreed.
Yeah. Not much to add on that, Charlie, other than you're right. Isha, you used the phrase Hail Mary. I think bringing a legal claim that hasn't had success since 1935 is probably a Hail Mary, and they didn't succeed on it.
Although it's worth noting, I should briefly say that the Supreme Court just last week granted a non-delegation case called Gundy versus the United States that was about whether the Attorney General can make regulations under the Sex Offender Registration and Notification Act that apply to people prior to the passage of the act. So we'll see where that's going. There might be a revival of the non-delegation doctrine, but at the time the plaintiffs filed this complaint, it was moribund, to be sure.
So, Isha, that's the hit on the non-delegation. Like I said, I think we're all in agreement on it. You and I, and maybe Charlie too, haven't gotten your opinion. Love this Shelby County equal sovereignty argument. You want to just describe it, and then we can get into it. And this is the last constitutional argument that we'll talk about in this case.
Yes. So I just think this is just a super creative and interesting way to deploy a fairly reactionary precedent for progressive purposes, which is something that's always like a little bit delightful to see. So Shelby County is the case where the Supreme Court famously struck down a provision of the Voting Rights Act that had required certain jurisdictions, largely in the South, to clear any changes to their voting procedures with the Department of Justice. And this was for obvious reasons, right? There were certain jurisdictions, largely in the South, that would impose tests, ID laws, moving around of polling places, redrawing of districts, rules about who could vote in the primary, specifically to disenfranchise non-white voters. And the Voting Rights Act sort of said, like, these jurisdictions, you gotta ask the Department of Justice and get federal clearance before you can change your voting procedures at all. Goes up to this, this has been in place forever, has been sort of reauthorized with bipartisan support for a really long time, goes up to the Supreme Court, and the Supreme Court basically says, no good for a lot of reasons, many of which didn't make a ton of sense. But one of the things they rely on is this notion of equal sovereignty. So they say, look, the states are equal sovereigns. You got to treat them equally. You can't just like single out these southern states for something that was true decades and decades ago and that you have no reason to believe is still true. And therefore, this is unconstitutional. And again, there's a lot more going on in Shelby County, but this is the kind of principle that this case is relying on. And so California comes into court and says, look, Shelby County established that this is a thing, the notion that the Constitution has this embedded equal sovereignty of the state situation. And actually, given that most most undocumented immigrants, as Charlie noted, get into the U.S. by coming here validly and overstaying a visa, not by crossing the border, you're kind of singling out California for no good reason. And you're going to take Californians' land and you're going to destroy California's environment. And it's not to curb illegal entry because this wall isn't going to do anything about that. So you have no principled reason for singling us out. And so it's just like the Voting Rights Act where they were singling out the southern states for no good reason. Here you're singling us out for no good reason. And you're going to put in this ridiculous wall. I thought it was kind of a neat argument. I thought it was, it works because Shelby County is kind of nonsensical, right? So in Shelby County, it's sort of it was obvious to a lot of people, including a really, really cogent, wonderful dissent, in that case written by Justice Ginsburg, why the particular states and jurisdictions had been singled out. That is, they had a really long legacy of entrenched racism. And yet the majority is like, we don't understand why you're picking on these poor states. And so it's sort of a nice move for California to sort of say, we don't understand why you're picking on us. Like, this makes the to the extent that you think even the formula for coverage in the Voting Rights Act didn't make enough sense to justify singling out states. Well, this certainly makes less sense than that.
So I think their argument here is exactly as powerful as Justice Roberts' opinion in Shelby County was, except that Justice Roberts is the Chief Justice and can decide to make a bespoke legal rule for one case that he really wants to rule in, right? And, my favorite law professor taught me not to call bullshit on a judicial opinion until you've really worked it through. But, we're reaching the end of the hour here, and it's just bullshit, right? So we can easily call bullshit on that. It's inconsistent with hundreds of years of American legislative practice, which regularly single out states for favorable and unfavorable treatment. I agree that as a general matter, there is some limit to how much one state can do or how much the Congress can do to one state, but not any other state. But neither the Voting Rights Act nor this delegation comes anywhere even close to reaching that kind of principled limitation on the, quote, equal sovereignty of the states, close quote. But, as I said, it's exactly as effective as the Chief Justice's statement. If it was true there, I really don't see why it isn't true here.
Exactly.
I mean,
yeah.
You can say, you can say sort of, yeah, okay, California, you're kind of being singled out, although eventually they do plan to build the wall in the other states too, right? So,
well, no, I think California is saying we're singled out not relative to Arizona and New Mexico, but relative to it makes just as much sense to put a border wall in Washington or Kansas as it does here, because it really has nothing to do with stopping illegal immigration.
That's not quite true. It's not. It doesn't do nothing to stop it, right? It may not be a good use of resources to stop people from entering the United States, because there are many other ways, and there are much less costly ways of deterring that. But it's not that it does nothing. I don't think they make the claim that it does nothing to stop someone from getting here, that a world in which there were no fence between the United States and Mexican border is identical in terms of how easy it is to get to the United States to one in which there is one. But so the reason I said, the comparison to those other border states is that Congress does appear to intend to treat all of the states that share a border with Mexico equally with one another, in a way that I think Chief Justice Roberts would say Congress does not treat all states that have discriminatory voting measures the same way, because his home state and Judge Curiel's home state of Indiana have atrocious voting rights legislation, and yet they were never subject to preclearance. But apparently Mississippi is reformed and they still are. I mean, as I said, I think that's all bullshit, but
right. And so that was the only point I wanted to make, which is that to the extent that you think history and legacy of racism that goes back centuries is not a good enough proxy to justify singling out southern states, I think it's a fair thing to say proximity to Mexico is not a good enough justification, good enough proxy to justify singling out states along the border. That's all. But neither of them make much sense.
And let me give that a little more meat on the bones, Isha, before we end, because I found, even though it may be right that the Shelby County argument, the equal sovereignty argument, is not a great argument, and it may not necessarily apply here, I found Judge Curiel's dismissal of it probably the weakest part of the opinion, which is, as we've said, quite thorough.
Yeah, I agree with that.
It's a dry read. But he gives it 2 sentences after describing the doctrine. And what he says is that, look, it doesn't violate equal sovereignty because this provision applies with equal force to any state that borders the U.S. And so then he says, inevitably, all states are not border states, and this state does not single out a particular state in imposing requirements on state powers. But I guess two responses immediately come to mind. One is, that's, I don't think, the best distinction. The best distinction is not between California and Arizona, at least as the law is written. It's between border states and non-border states. And California has an interest in enforcing all of its environmental laws and all of its criminal laws and stuff. And just because it's a border state, the government gets to come in and build this wall and waive all of them. But if the government does another public infrastructure project in Washington State or in Oregon has no border with Canada, or in Mexico, it doesn't get to waive them. So that's the argument, right? I don't think that Judge Curiel's dismissal really grapples with that. And two is that you can imagine, and this is a little harder in this individual case, but you could imagine that if the secretary were to use the authority in a way that discriminates against just the San Diego border wall, just against California, and not Arizona and Texas and other states that border Mexico, that this equal sovereignty could kind of have an administrative component. That's maybe a more advanced argument, and again, on this limited record and early in the Trump administration, we don't know that. But I took those to be really the two things going on here, and I just don't think Judge Curiel pitches his response at the exact problem that California has probably identified. That doesn't mean he's wrong.
It's probably worth noting, although this might be clear by now, that there's been exactly one circumstance in which this equal sovereignty principle has done any work, right? And it was in Shelby County. There was a brief mention of it in an earlier case that Chief Justice Roberts had sort of teed up for use in Shelby County, but in no other case has it ever done anything. So it's not like we can point to an example, and we can point to hundreds of examples in which Congress has done things, deliberately to favor states with key senators and deliberately to harm states without key senators. As for example,
the Cornhusker kickback.
Yeah, the Cornhusker kickback, this most recent tax bill, which seems it seems to be almost precision targeted at wealthy suburban Republican voters in blue states, which was a dumb political move on their part, but surely hurts California, New York, and New Jersey more than it does Texas, which doesn't have an income tax. I mean, yeah, there's really nothing there. It's exasperating.
Can I flag one more thing before we kind of leave this and move on to Trump nuggets?
Sure.
So the one last thing I just wanted to flag is kind of that the legal battle isn't over yet, right? So yes, there was this waiver, which means that, you don't have to do environmental consultation, which will speed things up. But one of the kind of lessons of the Secure Fence Act of 2008, so this is, as we said, the statute we're analyzing was originally passed to build 700 miles of border fencing back in 2006. But one of the takeaways is that it's actually very difficult to kind of grab the land that you need. So there's a process called eminent domain, which basically allows government entities to take land from private owners in order to do something that's sort of publicly beneficial. That's like how a lot of highways and stuff get built. But in order to do that, the Constitution has something called the Takings Clause, which requires that the government compensates you for kind of the fair value of your property. And it turns out that that's kind of trickier to do, particularly in places that are sort of rural and don't have like a robust market where you can say there are 10 properties just like this that were sold last year. So there was a lot of litigation, and the Texas Tribune just analyzed a set of 400 of these transactions where the government basically kicked landowners off their property and tried to compensate them, and basically found that people without lawyers kind of got screwed. So if you had a lawyer, you were likely to get 3 times the value of your property as if you didn't have a lawyer. B, that the government is just terrible at figuring out local property lines, so they would routinely compensate like the wrong person. And C, they just did a really bad job of kind of valuing the land. So they didn't value kind of these subjective things. Like, for example, if you run a restaurant and someone wants to take that building, they can't just give you the value of the building. There's also this sort of goodwill that's been built up over time because your customers know you, and you can't just buy another building somewhere else and achieve the same success, that sort of thing. So that's one thing I wanted to flag that is going to be a hurdle, particularly because over the past decade, it has become a hobby horse on the right to think about, talk about, and protest against the expansive use of eminent domain to sort of have the government take private property, right? It sort of reeks of communism. And so I think that's going to prove a little bit tricky. And then the second thing is part of the reason that this 700 miles was chosen back in 2006 is because a lot of the border is really tricky to kind of build on, both for kind of environmental reasons, like it's a hostile environment, but also because there are several Native American reservations that actually straddle the U.S.-Mexico border, which I didn't know. So, for example, the Tohono O'odham Nation Reservation, which is in Arizona and straddles the U.S.-Mexico border. In fact, if you have a tribal ID, you could just go back and forth across the border. You don't have to go through a border checkpoint. Has sort of its own sovereignty, and so the Secure Fence Act of 2006 couldn't cross that. And there's no way to really build a fence at the border without either having the fence kind of go around the reservation and leave a bunch of American soil on the Mexico side, or put a bunch of Mexican soil on the American side, neither of which seems like it's particularly palatable. So those two things, the inability to acquire the land, or at least the inability to do so without a profound political uproar, and the fact that we're talking about sections of the border that Congress 12 years ago decided were too inhospitable or complicated to build on, are the sections that are like left to fence in. I think will slow this down more even than this lawsuit.
But don't worry, we know where they're going to get the money.
Right.
Mexico.
Right.
Mexico's going to pay. Let's not forget. And I think it's also worth even parenthetically noting that no one seriously thinks they're actually going to build this wall. No one, it appears, including Donald Trump and most of his supporters. There's an interesting poll, and we'll link to it, that show that a lot of people who support Donald Trump actually recognize the things that he says as the bullshit that they are, which is really interesting to me. But yeah, it is really a symbolic battle here in a lot of respects, which is not to say that it's unimportant.
Right. Yeah. Jeff Flake, who's like supposedly, so we should also note that a lot of the senators of states along the border, most famously the New Mexico delegation, have come out and said, like, no dice on this border wall. Like, we don't want it in our state. But Jeff Flake said something like, well, if border wall is a metaphor for fencing plus surveillance plus drones plus camera towers plus hiring more border agents, then I think we all agree. And you're like, what? That's actually not what this is talking about. It says physical barrier. He's literally talking about a big, beautiful physical wall. But I think the Republican Party is trying desperately to massage border wall to mean, just like stepped up security in a variety of forms, for which the wall is just metonymic.
Yeah, they want to preserve their dignity. Constructive dignity, just like the constructive wall.
That's right. So with that metaphorical deep cut, and that was some deep cuts, Isha, let's wrap up the discussion of the border wall there. So that's the status. As we've said, this litigation is over in the district court. The Trump administration has won. The only option now for the state of California and the plaintiffs will be this cert petition to the U.S. Supreme Court to ask the Supreme Court to take the case. The Ninth Circuit is unavailable for review here because of this unusual law. So we'll follow if there's a cert petition that gets filed, but there will be no appeal of this. Okay, so really quickly, Charlie, Isha, before we end, I have one Trump nugget, and that is that a trial that probably hasn't gotten enough publicity is beginning now in Kansas, and it is a trial against the Secretary of State of Kansas involving that state's law that requires those who want to register to vote to have proof of citizenship. The ACLU has challenged this law as being irrational and being discriminatory, and most of the law has not gone into effect. Secretary of State Chris Kobach of Kansas, who we've talked about before because he was on President Trump's now disbanded Voter Protection Commission, is in charge of defending this law. And he has claimed that since 2000, 129 non-citizens in Kansas have either registered or attempted to register. But he's also said this is just the tip of the iceberg. We know the iceberg is much larger. So he claims that there's many more of these folks in Kansas that tried to register even though they're non-citizens. And now we have a trial, Charlie and Isha. And as you know, at trial, you don't get to just say things out of court. You don't get to just lie. You got to put on evidence. So I will be really curious to see what kind of evidence he's got, whether he has any evidence of voter fraud or non-citizens voting. I'm surprised it hasn't got as much attention because this is the forum for all these things that Republicans and Donald Trump have been saying, which is there's all these folks that can't vote, illegal aliens, non-citizens voting. Well, there's a federal court in Kansas that as of when you listen, listeners, is hearing evidence, according to the federal rules of evidence, about whether this is happening, and we will find out what happens. So stay tuned on that one.
Yeah, I eagerly anticipate the robust evidentiary showing that Chris Kobach will surely make. And listeners, I wanted to point out a glaring omission in my discussion of the case against Alex Vander Wal, the attorney at Skadden. And as I said last time and have to say again, I receive a fellowship from the firm, from a foundation with the same name as the firm, not from the firm itself. But yeah, so I forgot to mention that this Vander Wal guy is father-in-law is a big-time Russian oligarch whose name appears obliquely in the Steele dossier and is generally a sort of, I suppose, regarded as a shadowy character. I knew that fact. I was looking right at the New York Times article and somehow still did not mention it. Apologies, listeners. Several of you have helpfully pointed this out to me. It's an interesting story, and we all look forward to seeing where it goes.
My Trump nug is, hopefully we'll be able to do a whole episode on this, although there's so much happening over the next week that it's hard to pick and choose. But the New York Times just broke the news that the Department of Justice has decided to essentially mount a preemptive strike against California for several bills that were passed to try to protect undocumented folks who live in California. So California passed the California Values Act, which limits state and local agencies from sharing information with federal immigration agents, except for certain categories. They passed the Immigrant Worker Protection Act, which bars local businesses from allowing ICE to access employee records, and a couple of other bills to try to protect undocumented folks. And so taking a page out of the strategy that the Obama administration used against red states. So Obama administration famously sued Arizona for the Show Me Your Papers law, using a variety of what are called preemption theories, which basically says in the immigration arena, only the federal government can make laws, not the states. They've decided to sue California on this preemption theory to try to get rid of some of these statutes that are designed to sort of protect undocumented folks from the aggressive immigration enforcement regime of Donald Trump. So this is a really big deal, the federal government suing a massive state, and I hope that we cover it going forward.
Yes, that's not versus Trump in the caption. That will be Trump versus, but I think fits within the show's description. Charlie, Isha, this has been really fun. Listeners, we hope you've enjoyed getting into the weeds with us. You can find us at all the places we mentioned before, takecareblog.com/podcast, at versus Trump pod, versus Trump podcast at gmail.com. But in the meantime, Charlie, Isha, and listeners, we'll see you next week.
Thanks.
See you next week.
Bye.
The red light of the train